You are driving home. Red and blue lights appear in your rearview mirror, and here is the moment that determines everything. Not whether you get a ticket, but whether that stop ends in 60 seconds or turns into a case. Every day, drivers hand officers exactly what they need to search their car, seize their phone, call in a drug dog, and build criminal charges. All because they did not know 4 phrases. I have analyzed thousands of traffic stop cases, reviewed hundreds of body cam videos, and studied every controlling Supreme Court ruling on this area of law. Today I am giving you 4 phrases with the exact legal backing behind each one. 4 mistakes, 4 phrases. Memorize these, and you can end almost any traffic stop in 90 seconds. Stay through mistake 4. Passengers especially need this one because it is the most overlooked protection in all of traffic stop law. This is educational content only. For specific legal guidance, consult a licensed attorney in your jurisdiction. First, the first 30 seconds protocol. Before anyone says a word, use your turn signal, pull over safely, turn off the engine, turn on your dome light if it is dark, place both hands on the steering wheel where they are clearly visible. Lock your doors. Roll your window down 2 to 4 inches only, enough to pass documents, not enough for a reach-in. As the officer approaches, say, "For everyone's safety, I am also recording this interaction." That phrase frames your recording as protective rather than adversarial, and it is legal in virtually every state. Everything from this point forward is on their body cam and yours. That footage becomes evidence in any proceeding. Use that. Mistake number 1. Handing over your phone when an officer asks to see it. It always starts with something that sounds completely harmless. The officer leans toward your window and says, "Hey, can you pull up your insurance on your phone real quick?" That is a trap. The Supreme Court settled this with a unanimous 9-0 ruling in Riley v. California in 2014. 9 justices agreed. Police cannot search the digital contents of your cell phone without a warrant. Chief Justice Roberts wrote that cell phones hold the privacies of life, and that old search rules for physical objects cannot be mechanically applied to a device that contains more personal information than most people keep in their homes. Your texts, photos, location history, financial apps, private communications, all constitutionally protected. What Riley does not protect you from is voluntarily handing the phone over. Once you unlock it and pass it through the window, you have consented to what Riley was designed to prevent. Here is how the mistake plays out on body cam. Officer says, "Can you pull up insurance?" Driver unlocks phone with Face ID and hands it over. Officer scrolls through apps and notifications while appearing to look at insurance. Sees something. "Mind if I check a few things on here?" Driver says nothing to stop it. That footage just documented a voluntary consent to search. No warrant needed. Everything that follows is legally obtained. Here is the correct move. The exact words are, "I do not consent to a search of my phone." Riley v. California says you need a warrant. Say it calmly, politely, without attitude. "I do not consent to a search of my phone." Riley v. California says you need a warrant. If you have a paper insurance card in your glove box, produce that instead. If digital is your only option, offer to display just the insurance screen while holding the phone yourself, and state clearly you are not consenting to broader access. But say those words every time. Here is the layer most people miss. Your biometric unlock, Face ID and fingerprints, is legally weaker than your passcode. Courts are currently split. The Ninth Circuit ruled in 2024 that grabbing a suspect's finger to unlock a phone may not violate the Fifth Amendment because no testimonial act was required. The D.C. Circuit reached the opposite conclusion in early 2025, ruling compelling biometric unlock is testimonial and protected. What is settled? Compelling your passcode is testimonial self-incrimination under the Fifth Amendment. Before any traffic stop, disable Face ID and fingerprint unlock. Switch to passcode only. Your passcode is protected thought. Your face is legally vulnerable in many jurisdictions right now. Body cams are running. Handle this before you ever see those lights. If officers had grounds to search your phone, they would have a warrant. The fact that they are asking means they do not. The phrase is, I do not consent to a search of my phone. Riley versus California says you need a warrant. The bottom line, your phone is a constitutional vault. Never hand it over voluntarily. Enable passcode-only protection before every drive. And when asked, say those words. You have now protected your digital privacy under Riley. But Riley only covers what is inside the device. There is a completely different constitutional clock ticking on every stop. A clock that starts the moment you are pulled over and ends when the officer finishes the ticket. Mistake 2 is the silent mistake, because most drivers say nothing at all, while officers use that silence to buy time for a dog unit already on the way. Rodriguez versus United States drew a bright constitutional line. Here is what you must say before that clock runs out. Mistake number 2. Sitting quietly while a drug dog makes its way to your location. You are pulled over for a lane change. The officer takes your license and registration. Instead of going back to write the ticket, he leans on your door frame. So where are you headed tonight? You drive through here often? What do you do for work? These are not friendly questions. Officers are trained to use casual conversation to do one thing: buy time. The reason they need it? A drug dog is en route. Here is the legal framework. In Illinois versus Cabales in 2005, the Supreme Court held that a dog sniff conducted during a lawfully ongoing traffic stop does not violate the Fourth Amendment on its own. But in Rodriguez versus United States in 2015, the court drew a bright constitutional line. A stop cannot be prolonged beyond the time needed to handle the original infraction without independent, reasonable suspicion of additional criminal activity. Even 7 to 8 extra minutes for a dog sniff after the ticket was complete was ruled unconstitutional. The mission of a traffic stop is the ticket, license check, registration verification, and insurance review. Once that mission is done, the authority to detain ends. Any extension requires new, independent, reasonable suspicion. If there is none, you have the right to leave. Here is how the trap plays out. Officer: where are you coming from tonight? Driver: visiting family in Columbus. Officer: you do that often? Driver: yeah, a few times a month. Officer: everything okay? You seem tense. Driver: just nervous around police. Every answer adds to the officer's report. Every second is time the dog unit used to reach your location. Body cam captures all of it. When the dog arrives and alerts, false positive rates in some studies run as high as 40%. You made that evidence possible by talking. The correct phrase is, the purpose of this stop is complete. I do not consent to extending this stop. Am I free to leave? Say it respectfully and firmly. The purpose of this stop is complete. I do not consent to extending this stop. Am I free to leave? This puts the legal burden on the officer. Under Rodriguez, they must either let you go or articulate specific, independent, reasonable suspicion. They cannot hold you while a dog drives across town. If told you are not free to leave, respond, I understand. I am invoking my right to remain silent. Then say nothing more. Stay calm, stay polite, stay firm. Cooperation does not mean conversation. State variation matters here. In Colorado and Maryland, odor of marijuana alone is no longer probable cause to search a vehicle under state law. In Texas and Ohio, it still is. Know your state's specific rules. The bottom line, under Rodriguez, when the stop's purpose is done, your detention is done. Say the phrase. Do not answer small talk that buys time. That protects you on public roads. But what about your own driveway? Most drivers believe the automobile exception, the doctrine allowing warrantless car searches under certain conditions, applies everywhere they park. It does not. Collins versus Virginia established a protection that even attorneys sometimes overlook. Mistake 3 shows you the phrase that prevents a warrantless search on your own property before it can even begin. Mistake number 3. Assuming your car in your driveway is always searchable. You pull into your driveway. You are getting out when an officer appears and says, "We have been looking for that vehicle. I need to take a quick look." Most people step aside. They think it is visible from the street. It is just a car. They are wrong under Collins versus Virginia. In 2018, the Supreme Court ruled 8-1 that the automobile exception does not extend to the curtilage, the area immediately surrounding and associated with the home. The case involved a motorcycle parked in a driveway. An officer walked up, lifted a tarp without a warrant, confirmed the motorcycle was stolen, and arrested the owner. The court threw out all of the evidence. Justice Sotomayor wrote that curtilage is treated as an extension of the home itself for Fourth Amendment purposes, and that the justifications allowing warrantless car searches on public roads, ready mobility and pervasive regulation, simply do not apply to a vehicle parked on private property. The automobile exception has to stop somewhere. Collins says it stops at your property line. And in Lang versus California in 2021, a unanimous Supreme Court ruled that officers cannot follow a misdemeanor suspect into their home's curtilage without a warrant absent genuine exigent circumstances. The wrong exchange looks like this. Officer says he needs to look at the car. You say, "Go ahead." He walks around, looks through the windows, sees something in plain view. He now has probable cause. Search proceeds. The correct exchange. Officer says he needs to look at the car. You say, "My vehicle is on private property. Under Collins versus Virginia, you need a warrant to search it here." Calm, firm, no aggression. My vehicle is on private property. Under Collins versus Virginia, you need a warrant to search it here. The officer must leave, get a warrant, or demonstrate an applicable exception. Most cannot. Important variation: curtilage is a factual question about your specific property. A vehicle parked directly beside an enclosed entry point has very strong Collins protection. A vehicle on an open lot far from the structure may not. Know your property and consult an attorney for your specific situation. The bottom line: the automobile exception ends at your curtilage. Collins versus Virginia established this with an 8-1 ruling. The phrase is, your constitutional shield. You now have protection for your phone, your detention timeline, and your property. But almost every traffic stop video ignores one group entirely: passengers. They answer every question, hand over ID without hesitation, and unknowingly give officers the exact tool used to extend the stop and justify a search. Brendlin versus California gave passengers full Fourth Amendment standing. Mistake 4 shows you how to use it and shut down the most common officer tactic used against passengers at traffic stops. Mistake number 4: passengers answering questions and handing over ID without knowing their rights. You are in the passenger seat. The car gets pulled over. Officer leans in. "Can I get both of your IDs?" Passenger hands theirs over. "Where are you two heading?" Passenger answers. Maybe the answer does not match the driver's answer. Different destinations, different details. Now the officer has inconsistent statements from vehicle occupants. That inconsistency becomes the documented reasonable suspicion to extend the stop, request a dog, or conduct a search. Officers are trained to separate driver and passenger and ask identical questions to both. Different answers are exactly what they are fishing for. Here is the legal foundation. In Brendlin versus California in 2007, The Supreme Court unanimously held that passengers are seized for Fourth Amendment purposes during a traffic stop, just like the driver. Passengers have full constitutional standing. In United States versus Landeros, a 2019 Ninth Circuit decision, the court held that passengers are not required to provide ID unless individually suspected of criminal activity. Stop and identify laws vary by state. Some states do require all occupants to identify during a lawful stop, others do not. Know your state's law. But where not required, handing over that ID opens a conversation the officer had no right to start. Here is the separation play on body cam. Officer separates the passenger from the driver, asks the passenger, "Where are you headed?" Passenger says Riverside. Officer goes back to the driver. "Your passenger said Riverside. You told me the mall. Which is it?" One innocent answer from a cooperative passenger just created the inconsistency that justifies everything that follows. The correct phrase for any passenger is, "I am a passenger. I am staying silent. I do not consent to any searches of my person. Am I personally being detained?" Say it calmly. "I am a passenger. I am staying silent. I do not consent to any searches of my person. Am I personally being detained?" That invokes your Fifth Amendment right against self-incrimination, asserts your Fourth Amendment protection, and demands legal clarity on whether you are actually detained as an individual or merely present in a stopped car. Critical caveat. Under Maryland versus Wilson, decided in 1997, officers can order passengers to exit the vehicle during a lawful traffic stop. Comply with that order. Exiting is not consent to a search. As you exit, say, "I am complying. I invoke my right to remain silent and do not consent to any searches of my person." Hands visible, calm. Say it once, clearly, and then say nothing more. If told you are not being detained individually, follow with, "Am I free to leave?" Once the stop ends for the driver, your detention as a passenger ends too. Do not linger. Do not keep talking. Stay calm throughout. Stay calm. Stay calm. Rights asserted with aggression look like guilt on body cam. Rights asserted calmly look like constitutional knowledge, because that is what they are. Cooperation does not mean conversation. The bottom line, under Brendlin, passengers are full constitutional participants in every traffic stop. The phrase shuts down the separation tactic before it can work. The core principle behind everything in this video, knowing the exact phrase for each moment, removes the officer's ability to build a case through your own cooperation. You are not being difficult. You are being constitutionally protected. 4 phrases to memorize. 1. Am I free to leave? Establishes your legal status immediately. 2. I invoke my right to remain silent. It must be said out loud. Under Salinas versus Texas, pre-arrest silence without explicit invocation can be used against you in court. Silence is not enough. Say the words. 3. I want an attorney. Ends all questioning immediately. You do not need to be under arrest to invoke this. 4. I do not consent to searches. Fourth Amendment protection. Say it clearly once. Write these down. Practice saying them in a calm, neutral tone until they feel automatic. In the moment, every instinct will tell you to explain, cooperate, and be friendly. Your rights require you to resist that instinct. This is educational content only, not legal advice. Laws vary by state, and your situation may involve factors that change the analysis entirely. Always consult with a qualified attorney in your jurisdiction for your specific circumstances. Hit like, subscribe, and ring the bell. Share this with someone who drives, which is everyone you know. There are other constitutional protections we did not cover today, rights that work differently depending on exactly when and how you invoke them. I break all of that down in the next video on screen right now. Watch it. Let me know in the comments where you are watching from and what time it is right now. You do not need to be a lawyer. You just need to know the law before the officer assumes you do not.